Hello friends, welcome to the first episode of Indian Law Simplified, Kanun Hua Asan. Today we will discuss the Negotiable Instruments Act, that is, the provisions related to dishonor of check. Everyone who is doing business has a common worry. If I accept the payment in check and it is not honored, what will happen? Will I lose my money? Will I be able to recover it? So these answers are given in the provisions of Negotiable Instrument Act, section 138 onwards. Now section 138, though Negotiable Instruments Act is otherwise a civil law, section 138 makes it a criminal offense when a check is dishonored, and the punishment prescribed is up to 2 years and fine, which may extend to the extent of twice the amount of check. So law looks at it very seriously if you dishonor a check. Now, what has to be done? उसके लिए करना क्या होगा? That is the next question that comes to mind. There are few essentials. First, the check has to be against some debt or legal liability, and it is clarified in the act itself that it should be a legally enforceable debt, not any other debt, जिसको आप न्यायिक प्रक्रिया द्वारा एनफोर्स कर सके ऐसा ही ऋण होना चाहिए. But then, what has to be done? Check has to be deposited within the time of its validity. Validity was prescribed under the Act as 6 months, but Reserve Bank of India has changed it to 3 months. So now we have to be sure कि चेक 3 महीने में डिपॉजिट हो जाना चाहिए. सेकेंड, अब डिसऑनर किसको मानेंगे? What would be considered as dishonor of check? The check should be returned by your bank as not honored by the bank of drawer. It can be for reasons funds insufficient, exceeds arrangement with drawer, or even account closed. So immediately issue a demand notice. What is demand notice? You don't need a lawyer's help for that. You can write to the drawer that, sir, madam, on so and so date you had issued me a check and asked me to deposit it, and you had ensured that it would be cleared. But when I have deposited it within the period of validity, as per your instructions, it has been dishonored. So kindly make payment within 15 days, or this would become an offense under Negotiable Instruments Act. So here two things are very important. Notice has to go within 30 days and time of 15 days from the date of receipt has to be given. Now, if the payment is made, very good. So there is no offense. But if within the period of that 15 days payment is not made, you have to immediately file your complaint within the jurisdiction magistrate's court. The jurisdiction is to be considered as the criminal jurisdiction of the place where your bank, that is the drawee's bank, is. Suppose your bank is located at X place and Y police station is having the jurisdiction over that location. So you have to file in the court where that police station has jurisdiction. This has to be done within 1 month. Now there is a presumption in law that whenever a check is issued by a drawer, it is always issued against a debt or liability. But if that is rebutted and the drawer of check comes to the court and says that I had not issued any such check and it is not against any liability, then you have to establish that there is a liability. So these are the basic essentials. 1. A person must have drawn a check on an account maintained by him or her in a bank for payment of certain amount of money to another person out of that account. And this check should have been issued for discharge in whole or in part of any debt or other legal liability. And this check has been presented to the bank of drawee, within the period of 6 months from the date on which it was drawn, or within the period of its validity, whichever is earlier. So now period of validity is 3 months. And that check is returned by the bank unpaid, either because the amount of money standing to the credit of account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from the account by agreement between the drawer and the bank. The payee or holder in due course of the check. Now this is an interesting thing, because there is a concept of holder in due course. A payee can be a different person. Holder in due course is a person to whom an endorsement is made by payee, that instead of me, make payment of this amount to another person. So that person becomes holder in due course. Has to make a demand of payment of the said amount of money by giving a notice in writing to the drawer of the check. Now holder in due course cannot give a notice to the drawee, because drawee has simply endorsed it but has no liability attached to it. This notice has to be given within 15 days on receipt of the information, and drawer of such check fails to make a payment of the said amount of money to payee or the holder in due course within 15 days of receipt of said notice. So in the cumulative, it is only when all these ingredients are satisfied, a person who had drawn a check can be deemed to have committed an offence under section 138 of the Act. And you can file a complaint. The procedure of filing complaint is, it has to be in a writing, it has to be duly affirmed and verified. You have to produce all the original documents like check, receipt of the bank informing you about the dishonor, your statements of accounts, invoices and delivery challans to prove that you have that X person or the drawer had some liability towards you. And with these documents you can file your complaint. I hope this would have given you a brief understanding about how to deal with check bounce cases. You can follow us on Twitter, Facebook. Our handle is Juneja Legal. You can also follow our YouTube channel, Juneja Legal, where we would be uploading such podcasts as well as videos explaining different aspects of law. Thank you very much for listening to us. Do share, subscribe and support us in whatever way is possible with you. Thank you very much.